situation where an employee has committed an act of gross misconduct is likely to be a fast-moving, highly emotive course of events and will remain so for some time. Often an employee's career could be at stake, so any action taken by an employer should be reasonable and proportionate. Otherwise, the costs of acting hastily could be very significant. Joining me is Nicholas Evans, employment partner at Healys Solicitors, who regularly advises clients on how to deal with issues of gross misconduct. So hi Nick, thanks for joining us. So in terms of gross misconduct, how crucial is it for clients to set out what constitutes gross misconduct? And what should they really be aware of when they're drafting those sort of policies?
It's very important for clients to make it very clear to their employees what is and isn't expected of them in the workplace in terms of their conduct and their behaviour. So yes, it is important that that is clear. In drafting the policies, employers should generally give examples of gross misconduct. So for example, theft, violence in the workplace, bullying, harassment, that type of behaviour. But also that they should make it clear that that list is non-exhaustive. So it will be gross misconduct will include, but isn't limited to, those types of behaviours. Which means then that they have the freedom to pick up elsewhere what specific behaviours they may require of their employees.
So I mean, can an employer decide on a case-by-case basis? I mean, how subjective can it actually be?
Well, it can be subjective in the sense that different things may constitute gross misconduct for different employers. And if that is the case, then it's important that that's flagged up in policies and procedures. What an employer can't do is regard conduct by one employee as gross misconduct and then precisely the same conduct by another employee not as gross misconduct. Because there is obvious inconsistency there, which is unfair.
So I mean, sometimes the first natural step for an employer to take once they've been notified of an alleged misconduct is to suspend the employee. But actually, is that the right course of action?
No, not necessarily. The first thing an employer should do is consider how the alleged misconduct may impact in terms of whether or not the employee should be excluded from the workplace. If, for example, it's an allegation of perhaps harassment or bullying or something like that, then suspension may be appropriate, or alternatively it may simply be easier to move the worker to, the worker against whom the complaint has been made to another area of the operation. Suspension carries with it an awful lot of stigma, and even if subsequently the employee is cleared of anything, that there will be this sense of there being, no smoke without fire. So it's not something that should be a knee-jerk reaction, it's something that should be considered carefully. And the employer should ask themselves whether suspension is necessary for them to conduct an investigation, or whether suspension is necessary perhaps to take the perpetrator out of the working environment with, let's say, someone who's made an allegation against them.
So what about activities outside the workplace? Could they constitute gross misconduct?
Yeah, they could do. And the important thing there is for an employer to consider very carefully how conduct outside the workplace may impact upon the employment relationship, perhaps relationships with other employees, other members of staff. So if you've got bullying, harassment, for example, that may well be carried out outside the workplace, but nevertheless impact in the workplace. Use of social media is a big one these days, where people are putting on the various social media comments that perhaps they might have made verbally previously, but which are now there and there for many, many people to see. If, for example, a campaign of bullying or harassment was carried out, albeit outside the workplace, but which impacted on someone's ability to do their job, their relationships within the workplace, then there's no reason why that shouldn't be subject to disciplinary proceedings. In those circumstances, very important that an employer does include reference to social media, what is and isn't acceptable, in its policy and procedure.
So is there a different approach to where you've got a case where there might be a criminal sort of allegation compared to a contractual one?
In essence, no. Because, for example, many instances of gross misconduct may constitute technically criminal offences. So, for example, theft from an employer. or violence in the workplace. These, as well as being breaches of the disciplinary policy, would amount to theft, assault, and so forth. So, no, the employer should investigate properly. Sometimes that's difficult if, for example, there is a criminal investigation going on at the same time. But again, there's no obligation on employer to delay investigating and taking disciplinary proceedings simply because there are criminal proceedings as well.
So they can do it at the same time?
They can do it at the same time. What they need to be mindful of is what they're able to do in terms of investigation and making a decision, and what information they've got to base a decision on if there is an ongoing police investigation.
So when actually can you fire someone in that situation, and what should your clients really be mindful of if they're taking that course of action?
After due process. That due process doesn't need to take weeks or months or anything like that. It can be fairly short and sharp in appropriate circumstances. You know, with gross misconduct dismissals, there's three things tribunals look for. Has an employer investigated it properly? Does the employer have a reasonable belief in the guilt of the employee? And was dismissal reasonable in the circumstances? So an essential ingredient of a fair process and a fair dismissal is that the employer has undertaken a proper investigation. The worst thing for an employer in these situations is to be faced with someone who they know has committed an act of gross misconduct, and yet because the employer has failed to investigate it properly, has failed perhaps to give them the opportunity to respond to the allegations, has failed to to have a proper disciplinary hearing, that then gives the employee a claim in law. So process is very, very important and need not be onerous.
Great. Thanks, Nick. Thanks for joining us.
My pleasure.